Today on Off the Clock, we are going to be talking about those last minute, 11th hour, so to speak, changes to the Michigan Earned Sick Time Act. What changed and how it happened. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. Talking about ESTA a lot, all day, every day.
Yes, isn't it fun? It's the best time we've ever had practicing law.
It really is fun. And the nice thing is that clients just love it as much as we do, too.
I'm calling it the BESTA ESTA, the changes that were made.
Yes,
And in the intro, you said at the 11th hour.
literally at the 11th
You said
hour.
so to speak, but it's not so to speak. It was 11 o'clock at night before a midnight
Yeah,
effective date.
yes.
The changes
I know.
were finally voted through, and then, of course, not signed by the governor until the effective moment had
Right.
passed. So it could not have been more last minute.
It was in the world, in our world, about as dramatic as it gets.
Yes.
Right? I mean, the drama. We don't, I mean, you know that I was up past 11 at midnight, which for me in my work world is kind of a big deal.
So we stayed up late.
We stayed up late.
We read it so the clients didn't have to stay up late and do it. We both had the session on live for days on our phones, right, as we were doing other work, trying to see, trying to know exactly when it happened, when a change was made, and what happened.
Before we do that, can I just say one thing? Because I am still getting this question. Is anything else going to change? So I think let's just say out loud that we don't anticipate more changes occurring at this time. We don't see the legislature having an appetite for changing more. We think that this is it into the foreseeable future. So if any of our listeners are waiting still to make sure they know what they're supposed to do, now is the time to figure out how to change your policies and implement compliance with ESTA. Okay, with that, we're going to focus on what changed. We're not going to go back to the beginning and explain everything that ESTA requires. Instead, I think we're going to focus on what changed with those amendments. Is that right?
I think that's the best way to approach this.
Okay.
So first, let's just talk about what types of employees ESTA covers and what changes were made in the amendment. So employers got a little out of the changes, right? So certain employees are not covered anymore, such as unpaid interns, unpaid trainees, employees employed through the Youth Employment Standards Act, which basically means minors, right? Because that was a big issue for clients that hire a lot of high school kids.
Working under, to be clear, it's only minors working under a work permit.
Right.
So if they're emancipated or they've gotten their GED and are not working under a work permit, then the ESTA will apply to them.
That's one of the bigger changes. So basically, again, your typical high school kid is not going to be covered anymore. And then the other big change is something I've shortened up to gig workers, but it's actually broader than that. Right? It's employees who have no required hours of work and face no discipline or negative consequences if they choose not to work.
And if a business wants to take advantage of that exception, they do have to have a policy, which is kind of weird. It has to be somebody working under a quote policy that says there's no hour requirements and there's no adverse action if they don't pick up those hours. I've never seen such a policy, and I'm fairly certain most businesses don't have a written policy that says that, but that's not to say they couldn't adopt one, a simple policy, in order to take advantage of that exemption.
In healthcare, at least, that's the only place I have seen such policies, and they're typically referred to as PRN, right? Or substitute teachers, for instance, would be another example, right? We call you to see if you're able to pick up a shift and if you would like to when someone else calls in sick, right? And so those folks
and you'll stay on our list no matter what, even if you say no.
Those folks are not employees anymore who must accrue ESTA. That was nice for employers, not as much as they wanted. I think that's a theme throughout the changes. The employers' business community did not get all the changes they wanted, but there's a split of power in Lansing, and so this is a compromise. Pretty much everything we're going to go through, we're going to see as a compromise. Okay, what do you want to talk about next?
Let's talk about new hires. ESTA has taken kind of a strange position on this. You and I disagree with what ESTA has to say. We won't get into the weeds of exactly why. But Leo is saying that employers that front load time can't use that 120-day waiting period. Okay. Um, the fix for that, though, for employers that are maybe concerned about that, would be to say that employees accrue the time at a rate of at least 1 hour for every 30 hours worked during that initial 120-day waiting period. Okay. And then once that waiting period ends, if that business wants to front load, whatever time then would be required to get that employee to the 72 hours they're front loading or a prorated amount, that would be fine, and that eliminates that concern.
That's a great workaround. And yes, we have no idea why Leo is taking that position, but it is what it is,
Correct.
right? Let's take a pause for a short PSA to talk about what didn't change under the amendments, because we got a lot of questions about this within the first few days after the amendments passed.
Oh, you're talking about nonprofit
Of course, I am
agencies.
talking about nonprofit agencies.
Yes.
There was quite a bit of confusion in that first day. Let's just, because it didn't change, we'll just get through this very quickly. Leo has said that nonprofits are still covered by ESTA. And we here at Miller Johnson think that regardless of what the negotiations were late that night, the plain language of the statute supports that reading. So if you are a nonprofit that heard very early on that you're not covered by ESTA, you are.
Yes.
Yeah. Okay. Other changes. Other changes to the front loading versus
Yeah,
accrual
right.
aspect of ESTA.
So it was, Leo had previously said that, of course, an employer could front load time rather than accruing the time.
Yep.
The act didn't seem to contemplate a front load option prior to the amendments, and the amendments made that clear, which is very nice. They said an employer, rather than accruing 1 hour for every 30 hours worked, can instead front load 72 hours, or if the employee is a part-time employee, there's a specific way to determine the appropriate amount of the front load. And the nice thing about that is that it eliminated the need to sort of true up and make sure that a front load amount reflected the 1 hour for every 30 hours worked at the end of the year, right?
Yes.
Now we know 72 hours is enough to front load for a full-time employee, regardless of how many hours that employee works that year, which makes sense because they only get to use 72 anyway.
Yes. I know we're only talking about the amendments and not the original, but that's one of the things about ESTA that has always confused people.
Yeah.
Is the separation of in the concepts of accrual and usage.
Yeah.
Because before that, with PTO banks, you accrued PTO, and if you had PTO accrued, that's how much you could use. It was very simple. But then ESTA kind of separated those concepts, which created a lot of, I think, unnecessary confusion.
Right.
It doesn't actually help employees, right? Right. Okay. Anything else on front loading?
Just that. Why don't you talk about the carryover changes, because that's a nice segue to that.
Yeah. So that was a major complaint under the old ESTA, is that it was unlimited carryover of ESTA time, even though usage was capped. So it left people scratching their heads.
Yeah, including for a front load. So you would carry over time and then be front loaded the maximum amount you were allowed to use in the next year. On the first day of the year, you would get it all, but for some reason, employers had to carry over time.
It just
that somebody could never use.
It just didn't make sense.
Yes.
And so folks agreed that it just didn't make sense. So two different situations, depending on whether you front load or accrue. If you front load, you no longer have to carry over any ESTA hours to the next year. Okay. You can if you'd like, but you don't have to.
Right.
So that's nice. That was a nice change for folks. If you use the accrual method, you do have to carry over, but only to a maximum of 72
Right.
hours. So it's not like this unlimited
Mm-hmm.
amount. So that means if you accrue, and that makes sense, right? Because if you're using the accrual method and someone needs 72 hours of ESTA in January, it means they have up to 72 hours to take, assuming they had it from the year
Right.
before,
You got it.
to carry over. So that was a nice change for employers.
Calculation of pay, let's talk about that for a minute. I
Okay.
really liked this change, actually. The old ESTA used this term, quote, normal hourly rate, without defining what that meant. And
Yeah.
that phrase really um, has no legal meaning or really meaning in practice to HR folks,
Right.
right? We're used to, and we understand generally what phrases like base rate mean
Right.
and
Exactly.
regular rate mean, but
Different
normal
change,
rate,
yeah.
nobody knew what that was. So it gave an alternative between normal rate now and base rate,
Mhm.
and also made clear that that rate does not have to include extra incentive pay,
Mhm.
bonuses, tips, overtime, and things like that.
Right. Let's talk about notice to employees. The date changed, which was nice because, as we mentioned, the changes weren't even signed
Yeah.
until the effective date on
Right.
February 21st. So, how could we give notice of the changes? Uh, for so businesses now don't have to give notice to employees of their ESTA policies until March 23rd. Note that it's not the full policy even that you have to give notice of. It's certain specific aspects of the policy that are identified in the statute. Those did not change under the amendments.
I
It's just
think
the
that's the
effective
posting,
date.
right? That's the posting.
It's the posting plus you do have to let people know how you calculate a year.
Yeah.
So that would not be in the Leo
Yeah.
poster, but as
Mhm.
long as you have the Leo poster, right, and you hand that to people,
Yes.
and then somewhere in your handbook or your policy, you have how you calculate a year, and you
Mhm.
have everyone re-acknowledge your handbook.
Yes.
You're good.
Yes. Let's talk a minute about small businesses.
Well, first, what do we mean by small businesses?
This was an interesting change. Apparently, there was a strong lobbying effort by businesses with 10 employees. because, because
Why 10?
a change was made. In the old ESTA, businesses with 10 employees fell into the category, did not fall into the category of a small business, right? It had to be fewer, so 9 or fewer. You were a small business. With the change now, it's 10 or fewer. So, as I said, the lobbying efforts of those businesses with 10 employees paid off. They are now categorized as a small business. And there are two additional changes that are important to know. The first one I think is most important in that they get a special delayed compliance date, and that's
Yes.
October 1st.
Congratulations to all of you with 10 employees.
Yes,
Congratulations.
10 or fewer. And then also they did in the old ESTA, small businesses had to provide 40 hours of paid time and 32 hours of unpaid time. They did away with that 32-hour unpaid time requirement in the amendment. So now it's just the 40 hours of paid time.
So it's simpler, less burdensome and
Yes.
simpler, but only for the very smallest employers. So what's important to remember here is small employer or small business is defined differently than it is, for instance, under the FMLA.
The number is different, but how
Right.
you determine whether you reach that threshold is exactly the same.
That
It's
is the same.
20 or more calendar work weeks in the current or preceding calendar year to
Correct.
get to that threshold.
But
So you don't get there the minute you hire an 11th employee. You have to have
Yeah.
11 or more employees for 20 calendar work weeks in the current or preceding calendar year.
Yes, exactly.
Yes.
But if you are not covered by the FMLA,
Yes.
you may still be covered
Yes.
by ESTA.
Yes, yes.
There was
Good point.
an intense lobbying effort to change that, to have that 50 employee threshold, for instance. And so I just want to make sure all of our smaller, less than 50 employee listeners are aware that,
Yep.
that did not happen. So when you hear that there was some success in getting wins for small businesses, that was not one of the wins.
Yeah.
Okay, so still pay attention to ESTA.
Yep.
Okay. Are we ready to talk about enforcement? This is one of our favorite
I
pieces, or
think
do you
we
want to talk
have,
about
no,
some
I think we need
changes?
to talk about unionized
Oh,
workforces,
yes, yes.
employers with
Mhm.
collective bargaining agreements. This was the one change that was kind of a negative for businesses, quite
Mhm.
frankly.
Yeah.
In the language in the old ESTA, it said if you have a collective bargaining agreement in place, you didn't have to comply with ESTA until the expiration date of that existing collective bargaining agreement.
Mhm.
Interestingly, Leo had already taken the position that that language would apply only if your collective bargaining agreement would conflict with ESTA.
Okay.
We disagreed with them on that too.
It happens.
Sorry, Sean.
It happens. Yeah.
Yes, exactly.
It happens.
Sorry, Sean. And then with the ESTA amendments, that language got incorporated into the amendments.
Mm.
So the end result for businesses with collective bargaining agreements is if you have a collective bargaining agreement in place and that collective bargaining agreement has a provision in it addressing PTO or sick time or really any other paid time off policy that employees could take for the reasons under ESTA,
Mhm.
you can still wait until the expiration date of
Okay.
that contract to comply with ESTA because there would be a conflict.
Okay.
If, however, that collective bargaining agreement is silent as to paid time off benefits, which could be the case,
Mhm.
some businesses provide even unionized employees paid time off through policies and not the collective bargaining agreement.
Yes.
Then the amendments do require you to comply immediately with ESTA, which we understand is impossible because you have to bargain with the union over it. So the idea that you were supposed to comply on February 21st is impossible,
Right.
but those employers should be coming up with a plan to meet with the union and talk to the union about implementing compliance with ESTA.
Got it. Okay. So kind of a headache for our clients.
Yes,
With
that
these. Is
summarizes things for you.
Okay. All right.
So the only other change is that language regarding the obligation to restore the time if you rehire an employee within a certain period of time. That now has been shortened from 6 months to 2 months.
Okay.
So the rule is now if an employee, if employment ends and you don't pay out unused sick time when their employment ends,
Mhm.
if you then rehire them within 2 months, you've got to restore that time and it's got to be immediately available.
That's nice because it's far less likely, of course, to be rehired in 2 months. So that
Yes,
makes it
and
easier
it'll
for employers.
correct. It
Yeah.
eliminates the concern about your maybe seasonal employees who
Yeah.
come and work a few months in the summer and then a little bit over Christmas, right? And then,
Right. Mhm.
I think that that was probably the driving force behind that. So let's talk about enforcement because, quite frankly, and you know, I've said this many, many times, I think this is the most important change.
Yeah. It's
The
the most
lit,
important practical
correct.
change. It's not getting as much chit chat amongst the HR
No.
folks, but let's talk about the impact it does have.
On businesses, right?
On businesses. So under original ESTA, Leo could enforce, or there were private causes of action, which means an employee who thought that you got it wrong could take you to court. And so that's what it means to have a private
Yeah.
cause
And
of action.
potentially bring a collective action if you think
Mhm.
the whole program is being applied incorrectly and people are being denied the right amount of paid time off, for example.
Yeah.
At the wrong rate, or it's not being measured correctly, or the carryover is not being done correctly, right?
Mhm. Yeah.
You could have plaintiffs' lawyers poised, ready to file lawsuits on behalf of individuals to make those claims.
But under the BESTA ESTA,
The best of ESTA. That's right.
the private cause of action was removed.
Yes.
So now the only enforcement mechanism is through the state, Leo, this agency we've been talking about, right?
Yes.
So what does that mean for employers then? If an employee does believe that the employer made a mistake, they have to file a complaint with ESTA.
Correct.
I'm sorry, with Leo,
With Leo. Yeah.
right? And then Leo looks into it, and worst case scenario, we make it right.
We make it right. Leo does have the ability to file a lawsuit
Mhm.
on behalf of the individual if it gets that far. I would think in almost every circumstance, if a complaint is made, Leo's going to look into it.
Yeah.
And if a mistake was made, the employer is probably going to resolve it through that administrative process fairly easily.
I agree.
I don't think Leo's going to have a lot of interest in investing its time and resources in filing a whole bunch of lawsuits against businesses.
Right. I completely agree. My instinct is that if there is a good faith effort,
Yeah.
to be complying, and maybe, we read something or applied something a little off,
Yes.
they're going to let us adjust it, and that'll be that. One of my favorite parts about this change is because Leo is the only enforcement mechanism we need to think about or care about. Leo can tell us at any time, and they have almost immediately on some things, how they are interpreting
Right.
some gray areas in
Right.
ESTA. With private causes of action, we have to wait for a lawsuit to be filed.
Right.
And the particular issue we have a question about, right, wind its way through the court system. No one settles, right? And the court actually says, oh, this is what nonprofits are covered or not, just to use that as an example. We would have been waiting years to get an answer on that. But because all we have to worry about is Leo, Leo can tell us Leo's interpretation. And while we may not agree, which happens, or we might not like it, what I have found with organizations, anyone who employs people, they can deal with it. They can deal with the bad news, right? Or that being interpreted in a way that is less favorable to them or their employees. But they just need certainty. Just tell us what to do. Tell us what the answer is, and we will do it. And with Leo Leo being the enforcement agency, they're going to get that certainty, I think, a lot easier and a lot faster.
Right.
So that is a very
Agreed.
practical, in addition to not having to defend
Right.
lawsuits, a very practical reason why this is helpful.
Right.
Yeah.
Rebecca, we missed one important change.
Oh, what's that?
The increments.
Increments. That's because we don't love talking about it. I'm not sure Freudian slip is
Right.
the right way to
Yes.
describe why we
Yes.
missed that.
Yes.
But lots of talk about
Speaking
increments.
of Leo's interpretation,
Yes.
let's just say this. First of all, the change is favorable to businesses, but the language remains confusing in the act itself.
Right.
Leo has interpreted the confusing language to say employers can require employees to use the time in as great as 1 hour increments, but no more.
Correct.
But at least we're not looking at the minute increments or the 15-minute increments.
Right. Yes. Now, I mean, that's one area where we may disagree with Leo's reading,
Yes.
right, of the statute, but they're the ones enforcing it. So as long as they're the ones enforcing it,
Right.
and that's the way they're reading it, that's what, if employers do not want to take any risks regarding compliance, that's the method they should use.
Yeah. Absolutely. Excellent.
Okay. Have we talked enough about ESTA?
We have.
We have.
We have for a lifetime. Yes.
Right. Now we'll go back to our client meetings to talk about it one-on-one. One last mention about ESTA. I'm sorry, I know we were so happy to be done with it, but we're getting lots of emails about PTO policies and revisions to PTO policies. Please remember your attendance policies too.
Right.
Okay, so that's just one little plug. We're not going to go through all of this, how ESTA impacts attendance, because that's not really related to the changes, but I just want people to keep in mind
Right.
that they need to pay attention to attendance in addition to how they're working their PTO policies.
And within those attendance policies, top of my list when you're looking at it is to make sure you have written call-in rules if you would like to enforce those call-in rules. So
Yes, excellent point. Okay, thank you, Sarah.
thanks, Rebecca.